I'm Ben Meiselas from the MeidasTouch Network. Federal Judge Donald Middlebrooks from the Southern District of Florida just issued a scathing dismissal of a disqualification request by Donald Trump and Trump's lawyers. This is the second disqualification request made by Donald Trump and now by one of Trump's new lawyers, someone from a firm called the Bedell Law Firm or something like that, Jared Roberts, who previously tried to attack the MeidasTouch Network as well, called us hacks, and then said Trump 2024 with an American flag. Well, two scathing orders just came out by Judge Donald Middlebrooks, one rejecting Trump's request for an indicative ruling and the other one rejecting Donald Trump's second request to disqualify him. What's notable, and we'll go over this in the video, in Trump's first request to disqualify Judge Middlebrooks back in 2022, Judge Middlebrooks knew all about Judge Aileen Cannon's corruption back then. And in a footnote, Middlebrooks says, I see what you're trying to do. And again, this was before Middlebrooks issued the sanctions against Donald Trump. This was before the search warrant was executed at Mar-a-Lago when Judge Cannon was assigned the case in August of 2022. Yep, back in April of 2022, in a footnote, Judge Middlebrooks called out Trump's attempt to try to get Middlebrooks disqualified to go to Fort Pierce before Judge Aileen Cannon. This is all the case. If you're wondering, what case was Judge Middlebrooks on? What are you talking about, Ben? This is the case that Donald Trump filed against Hillary Clinton and like 32 other people. Trump filed a RICO case. Alina Habba was his lawyer, and the court said this was one of the most frivolous lawsuits that the court had ever seen. Every single accusation was false and frivolous. The court granted nearly $1 million in sanctions against Donald Trump and Alina Habba. And then what did Donald Trump do in July with a new lawyer and law firm, this Jared Roberts guy, this first-year associate? They brought a motion for indicative ruling to reinstate the case, saying the Durham report vindicates Trump, which it absolutely doesn't. And in another scathing order issued the same time as the scathing order I'm talking about now, Judge Middlebrooks is like, absolutely not. I've read the 306-page single-spaced Durham report. It does nothing. And even if it conceivably makes sounds that somehow fit into a narrative that you're trying to make, the legal ruling that I've made before completely would preclude it anyway. And also, the Durham report doesn't say what you say the Durham report says. We reported that here before. The only thing the Durham report recommended was that there be a preliminary investigation before a formal investigation into Donald Trump. But it actually made no recommendations that the FBI should change its conduct any differently at all. And then the two prosecutions that were brought by John Durham before a jury trial, both individuals who were tried criminally were found to be innocent very, very, very shortly after jury deliberations. John Durham is a complete and utter failure. By the way, just compare that right now to the Department of Justice, which has charged thousands of insurrectionists and won every single jury trial case. Think about that. The two cases that Durham tried, Durham lost. So let's take a look right here at the motion or at the order that was just granted where the Judge Middlebrooks dismisses the motion to disqualify him and notes that it is the second time this was attempted. Here's how it starts off. Judge Middlebrooks goes, on August 14, 2023, while an appeal was pending and after the appeal was stayed for the purpose of seeking an indicative ruling for relief from judgment pursuant to Federal Rule of Civil Procedure 62.1, movants filed a motion to disqualify. Given the limited remand by the Court of Appeals, I do not believe I have jurisdiction to even consider this motion absent further authorization. Moreover, if the remand permits an indicative ruling, I would not grant the motion and do not believe it raises a substantial issue. And so basically here, Judge Middlebrooks is saying, I'm divested of jurisdiction the moment you filed your frivolous appeal, but even if I was not divested of jurisdiction, I'm going to let you know on the merits how I feel about your motion to have me disqualified. And here's what Middlebrooks says. So if the remand allows for an indicative ruling on the motion to disqualify, I would deny it. And the court says, it cites a case, quoting Judge Jerome Frank, he stated, impartiality is not gullibility. Disinterestedness does not mean childlike innocence. If the judge did not form judgments of the actors in those courthouse dramas called trials, he can never render decisions. Of particular resonance here, he also said, quote, also not subject to deprecatory characterization or as bias or prejudice are opinions held by judges as a result of what they learned in earlier proceedings. It has long been regarded as normal and proper for a judge to sit in the same case upon its remand. Movens complains, this is the best part. He goes, so Trump complains that, quote, I went above and beyond the defendant's arguments and conducted extrajudicial research. The judge goes this, he goes, this seems to be a pejorative misnomer. In my 2 orders on sanctions, I conducted limited independent judicial research in every instance in response to arguments made by the parties. I looked at, judicial decisions, legal filings, and statements not subject to dispute and directly made by Mr. Trump and his lawyers. In each instance, I cited the source for the information. From the very first filing, the defendants contended that the case was frivolous and brought for an improper purpose, whatever the utility of plaintiff's complaint as a fundraising tool, press release, or list of political grievances, it has no merit as a lawsuit and should be dismissed with prejudice. Pointing to his litigation against Letitia James, Twitter, CNN, New York Times, the defendants described Trump as a serial litigant who brought cases against his perceived foes for political fundraising purposes, for political and fundraising purposes. In their filings, the plaintiffs referenced the DOJ Inspector General report on the Crossfire Hurricane investigation, the Mueller report, the indictments of Mr. Danchenko and Mr. Sussman, a letter from John Ratcliffe to Senator Lindsey Graham, and the Justice Department's announcement of the appointment of the special counsel. I read all of the filings and each of the documents. I have now also had the opportunity to read the Durham report. Goes on and says, look, the Letitia James case was filed in state court in Palm Beach County, removed to federal court, and assigned to me. In large part, the complaint was copied verbatim from that filed and dismissed in federal court in New York. On the day after it was filed, Trump posted a statement on Truth Social attacking the New York State court judge before whom the civil action being brought by A.G. James was pending. Mr. Trump said it was vital for courts in both New York and Florida to do the right thing and stop this inquisition. I denied the emergency motion for temporary injunction because none of the prerequisites for an injunction were met, and the attempt to sidestep rulings by the New York courts by suing A.G. James personally was plainly frivolous. I also said that the litigation had all the telltale signs of being both vexatious and frivolous. The CNN and Twitter litigation were filed in the Southern District of Florida and assigned to other judges. In my order, I quoted the fundraising appeals made by Mr. Trump, which accompanied the filings. The Twitter complaint was also relevant to the sanctions order because there Mr. Trump blamed his suspension from Twitter on Democratic members of Congress, Vice President Harris, and Michelle Obama. In the amended complaint before me, he said Clinton was responsible. I also directly quoted the demand letter sent by Mr. Trump's lawyers, his statement announcing his intention to sue, and the complaint filed in the state court in Florida against individual members of the Pulitzer Prize Board. Based upon the arguments of counsel and the work I did, I came to firm conclusions and expressed them carefully in each of the 3 orders. Different legal standards were applicable to the motions to dismiss and the motions for sanctions. I did not comment on the merits of any undecided case, and where cases had been decided in whole or in part, I directly quoted from the respective orders. The case before me was frivolous. Its purpose was improper and part of a pattern of behavior harmful to the rule of law. Article 3 judges have an obligation to protect the administration justice from abuse. For the reasons stated above, the motion to disqualify is dismissed for lack of jurisdiction. If the remand allows for indicative ruling, I would deny the motion. Signed in Chambers, West Palm Beach, Florida, the 15th day of September 2023. So I say to you, Jared Roberts, the second-year associate, I told you so. I told you this was going to happen. Great way to start your career. I'm Ben Meiselas from the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Check us out at patreon.com/MeidasTouch. patreon.com/MeidasTouch, and wherever you get audio podcasts, subscribe to the MeidasTouch podcast. Have a great day.
Hey Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.